Okay, let's unpack this. We are diving into one of the most, let's say, frustrating and often litigated areas of contract law, the statute of frauds. Specifically, we're tackling that infamous one-year rule.
Ah, yes, the one-year rule.
Exactly. This is the rule that asks a really simple question, but wow, the answer can be mind-boggling. When does an oral agreement absolutely have to be in writing because it just can't possibly be done within 1 year?
It sounds like a common sense question, doesn't it?
Hmm.
But you're right, the legal answer often seems to actively defy common sense. Our mission today is to take the, well, frankly, dense legal reasoning from a key case, C.R. Klewin, Inc. v. Flagship Properties, Inc. That's the landmark Connecticut Supreme Court decision, and turn it into something useful. A clear, element-by-element analytical checklist for you.
Okay, good. Because the core conflict, the thing that seems to come up again and again, is figuring out the line. You know, the line between an oral agreement everyone expects will take years. Think of a massive construction project.
Right, like in Klewin.
And an agreement where the contract terms themselves make finishing in a year truly, technically impossible. So the big question is, does exceedingly unlikely mean the same thing as impossible in the eyes of the law?
That's precisely the heart of it. And to answer that, we really have to understand why this rule gets so much criticism from courts. We'll need to break down the Klewin case, the facts, the court's holding using a really rigorous approach.
Yeah.
We'll focus on how narrowly the court interpreted this rule, basically calling the one-year provision an anachronism.
Anachronism. That tells you a lot right there. It sounds like something old, outdated. Why is a rule that apparently made sense back in, what, 17th century England still causing so much trouble today?
Well, because many argue it's just poorly aimed for its supposed purpose. The core doctrine we're examining today is this critical difference between a theoretical possibility of performing the contract within 1 year versus the realistic expectation, or even the realistic impossibility of doing it that fast. The law, strangely enough, focuses almost entirely on the theoretical. As the court in Klewin pointed out, the rule feels ill-contrived. Think about it. If the goal is preventing fraud due to bad memory, why does the clock run from making the contract to completing performance, which could be years later, instead of from making the contract to the court date? It's puzzled commentators for ages.
Okay, that does seem odd. So let's start with the absolute basics then. What's the general point of the statute of frauds overall, and how does the specific one-year part usually work with oral contracts?
Right, so the statute of frauds, big picture, it requires certain types of important contracts to be in writing. The main goal is to prevent fraud and people lying about agreements perjury. The section we care about today, the one-year provision, specifically says you need a writing for any agreement that is not to be performed within 1 year from the making thereof. Now, the general rule, and this goes way back, is that this part of the statute only kicks in if the contract's own terms make performance absolutely impossible within that 1 year time frame.
Absolutely impossible. Okay. But if the whole point is fighting fraud, why have courts seemed so, well, unhappy with this specific rule? You said they look on it with disfavor and try to limit it.
Exactly. It's because, as many courts, including the one in Klewin, noted, it no longer seems to serve any purpose very well. That's a direct quote. Instead of actually preventing fraud effectively, it often ends up being used as kind of an arbitrary technicality, a way for someone to wiggle out of a deal they genuinely made just because it wasn't written down.
Ah, I see. So it could shield bad actors.
Potentially, yes. So courts tend to prefer interpretations, constructions that narrow its scope, that limit its application. They know that sometimes the only real effect of this rule is to block potentially valid claims just because of this writing requirement.
Okay, that context is crucial. It sets the stage for why Klewin is so important. We need to see how this judicial skepticism plays out. Let's analyze C.R. Klewin, Inc. v. Flagship Properties, Inc. Let's start with the facts. What are the concrete details, the legally important bits about what happened between Klewin and Flagship?
Okay, fact summary. So you have Klewin, the construction manager, suing Flagship, the developer. They had an oral contract, apparently sealed with just a handshake.
A handshake deal for a huge project.
Yep. For Klewin to manage all phases of this enormous project called Contact, we're talking $120 million, 20 buildings, a hotel, housing, massive scale. Now, critically, everyone involved expected it to take a long time. Somewhere between 3 and 10 years was the expectation. And the trial court actually made a finding on this. It said finishing within 1 year was exceedingly unlikely and even realistically impossible.
Realistically impossible.
But then, after Klewin finished the first phase, Flagship replaced them. And that's what led to the lawsuit for breach of that oral agreement.
Got it. Big project, oral deal, expected to take years, gets cut short. So what exactly was the legal question the higher court needed to answer? What was the core legal issue?
Right. The issue is really twofold, certified up to the Connecticut Supreme Court. First, is an oral contract like this, one that doesn't explicitly state an end date, considered a contract of indefinite duration, which would mean it's outside the statute of frauds? And second, or is an oral contract unenforceable if everyone clearly contemplates it will take more than a year given the sheer scope, even if the contract doesn't literally say this must take more than 1 year?
Okay, that frames the dilemma perfectly. So what rule of law did the court apply to resolve this? Can you state the full black-letter rule from the holding and then, crucially, break it down into the testable elements for us?
Absolutely. The court came down firmly on the side of the narrowest possible reading of this statute. So, the black-letter rule. Klewin holding. An oral contract that does not say in express terms that performance is to have a specific duration beyond 1 year is, as a matter of law, the functional equivalent of a contract of indefinite duration for the purposes of the statute of frauds. What that means is it's enforceable if performance could possibly be completed within a year. That's the key word, possibly. It doesn't matter what the parties expected or what the actual probability was.
Wow. Okay, possibility, not probability. And based on that holding, what are the, let's say, two essential testable elements someone needs to check when applying this rule?
Yeah, it boils down to two main checks. The testable elements are, one, did the contract contain express terms that specifically required the performance duration to be longer than 1 year?
Oh.
And two, was the agreement structured in such a way that, according to its own terms, performance could not possibly be completed within a year? Was it absolutely inconsistent with finishing in 365 days?
Thank you. That's crystal clear. Now for the court's elemental analysis. Let's walk through the reasoning step by step, element by element. How did the court apply that first element, the one focusing on the lack of express terms, setting a duration beyond 1 year?
Right. Elemental analysis, element one, express terms. They looked at the agreement, the oral promise to manage all phases, and found there was no express provision at all that directly or even indirectly regulated the time for performance. The deal was simply, you've got the job. That's it. Since no specific duration over 1 year was actually required by the terms agreed upon, I mean, theoretically, the parties could have decided to pour massive resources in and speed everything up.
Unlikely, but possible under the term.
Exactly. Because the terms didn't forbid it, the court said it was legally the same as a contract of indefinite duration.
Yeah.
So element one was not met. The statute didn't apply based on duration alone.
Understood. But hang on, this still feels weird. How can the court just ignore the sheer scale? A $120 million project, everyone knows it's going to take years. Let's move to the second element. How did they analyze whether the contract could not possibly be completed within a year based on its structure?
Yeah, this is where it gets really counterintuitive. Elemental analysis. Element two, absolute possibility. Flagship, the developer, argued exactly that point. They said, look, possibility has to mean reasonable possibility. They argued that the physical and logistical reality of building 20 structures for $120 million made it impossible in 12 months, and that should be enough for the statute to apply.
That sounds like a common sense argument.
It does. But the court flatly rejected it. They cited very old precedent, like a famous case called Warner, and stuck to the traditional narrow view. They held the question is not what the probable, expected, or even actual performance time frame was or would be. The only test is whether the contract, interpreted reasonably based on its terms, actually required the performance extend beyond 1 year. Since the contract just said manage all phases and didn't include any terms prohibiting a super fast, maybe unrealistic completion, that theoretical possibility remained open. So element two was also not met.
Wow. Okay, so even realistically impossible, as the trial court found, doesn't cut it. It has to be impossible according to the contract's own rules.
Precisely. The terms are paramount.
Okay, that standard is something else. So after analyzing both elements, finding no express terms forcing a longer duration, and finding no absolute impossibility baked into the contract structure, what was the court's final conclusion?
Conclusion. The bottom line was the oral contract was enforceable. It fell outside the statute of frauds. The court basically locked in the standard. It's about absolute impossibility, judged only by the contract's express terms. You ignore expectations, ignore scope, ignore realistic timelines. Because Klewin's contract didn't expressly demand more than a year and didn't make completion within a year theoretically impossible by its terms, the oral agreement stood. It was outside the statute's limiting power.
Right. So what does this really mean for you, the listener, trying to apply this? It sounds like the huge takeaway is you must focus on theoretical possibility over realistic probability. Let's maybe try a quick thought experiment to really hammer home that distinction, something maybe a bit visceral. Okay, hypothetical one, the test of physical impossibility. Imagine some company hires you under an oral contract, your job, to do something just absurdly physically demanding, let's say. Dig a huge Olympic-sized swimming pool, entirely by hand, using only a teaspoon. Everyone knows this is physically impossible for a human in a year. You yourself admit, yeah, this will probably take me 50 years. Does the one-year provision kick in? Does that contract have to be in writing?
Huh. Okay, the teaspoon hypothetical. Analysis? No. Surprisingly, the statute of frauds does not apply there. The law, in this specific weird context, basically ignores realistic human capacity, physical limits, even things like, likely mortality over 50 years. While digging that pool with a teaspoon in a year is obviously realistically impossible. The contract terms themselves, assuming they just say dig the pool, don't state you must take longer than 1 year.
So the terms don't forbid superhuman speed.
Exactly. If theoretically you suddenly developed, I don't know, superhuman digging powers and could finish in 365 days, the contract terms wouldn't stop you. Because that theoretical possibility exists under the terms, however ridiculous, the contract is considered capable of performance within a year and is enforceable, even if it's just oral. Reality doesn't matter, only the terms.
Okay, that makes the distinction crystal clear. It's purely about what the contract allows or requires, not what reality dictates. Now let's flip it. Let's look at the converse situation, the kind of example that really shows why people call this rule an anachronism. Hypothetical 2, the stipulated delay. So imagine instead you make an oral contract today. You agree to do a very simple job for your neighbor, say paint their fence. It's a one-day job. Easy. But the agreement specifically says you will do it on December 15th of next year. So that's 13 months from today. Does the statute apply to that simple one-day job?
Analysis, yes. Absolutely, the statute applies there. That oral contract is unenforceable without a writing.
Even though the work itself is trivial.
Doesn't matter how easy the work is. It's because the express terms of the agreement, the specific date you agreed on, stipulate a performance date that is more than 1 year from the date you made the deal. The terms make performance within 1 year impossible. Performance is set for 13 months out. And this highlights the exact absurdity commentators hate. The one-day fence painting job is barred because the timeline was explicitly set beyond a year, while the massive multi-million-dollar contact project in Klewin, which everyone knew would take 10 years, is enforceable because the timeline wasn't explicitly fixed in the oral agreement. It's all about the terms.
That really drives home how technical and, frankly, counterintuitive this rule is. Okay,
Right.
We've looked at the history, the policy critique, the definitive Klewin ruling, and these hypos. So for our listener who needs to maybe spot this issue on an exam or analyze a real-world situation, how do they boil all this down? How do you synthesize this into an actionable step-by-step checklist for tackling an oral contract under the one-year rule?
Okay, absolutely. If you're faced with an oral contract and you need to test it against this 1-year provision, here's a precise diagnostic framework, basically the Klewin test distilled. 1. Issue spotting. First, just identify if the duration of the oral contract is even being challenged. Are we asking if it must be in writing because of how long performance might take? 2. The Klewin test. Step 1. Check for express terms. Look very carefully at the actual terms of the agreement. Does the contract specifically require performance to take more than 1 year? If it says this agreement will last for 18 months or performance is due 13 months from today, then yes, the statute applies. Needs a writing.
Okay, so look for that explicit date or duration first.
Exactly. 3. The default rule, step 2. Assess absolute possibility. If there's no explicit duration stated beyond 1 year, meaning the contract is for indefinite period or the end date is uncertain, then the statute applies only if performance is absolutely inconsistent with completion within 1 year, according to the contract's own structure and terms.
Absolute inconsistent, meaning not just unlikely, but impossible under the terms.
Correct. And that leads to 4. The exclusion. This is critical. You have to consciously, deliberately ignore what the parties expected. Ignore how likely or probable performance within a year seems. Ignore the practical difficulties or the scale of the project. If there is any theoretical way, any contingency allowed by the contract's terms, short of, acts of God or things not related to the contract itself, under which the entire task could possibly be completed in 365 days, then the contract is outside the statute of frauds. It's enforceable even if it's oral.
Got it. So check express terms first. If none, check if the terms themselves make completion in a year absolutely impossible. Ignore everything else, expectations, probability, common sense.
That's the framework. Technical, narrow, and focused solely on the contract's language.
That was a really rigorous walkthrough of the 1-year rule. I think the main takeaway for you listening is crystal clear now. The law, at least in this area, prioritizes technical interpretation of contract language and a very narrow application of the statute over what might seem like everyday common sense. Realistic impossibility doesn't matter. Only express terms forcing performance beyond a year, or terms making completion within a year absolutely theoretically impossible, will trigger the need for a writing.
Right. And we spent this deep dive focusing on how courts, following Klewin, use this narrow interpretation to limit the statute's, well, its destructive force, as some might say. They're trying to prevent it from barring potentially valid oral agreements.
Which definitely raises a final interesting question to think about. If courts are consistently refusing to broaden this 1-year rule to cover situations that are realistically impossible to complete in a year, especially in our modern economy with complex long-term deals, what other tools are there? Are other parts of the statute of frauds becoming more important, or are courts using other doctrines entirely to guard against actual fraud and perjury when there's no written contract for these big long-term oral agreements?
That's a great point. If this rule isn't doing the job effectively, what else is filling the gap, or should be?
Exactly. Something to definitely mull over as you take this framework and apply it.